Okay, so let's jump right in. Imagine getting into a major fight with your neighbors, a fight over a piece of land that's about the size of 4 basketball courts. Well, that's exactly what happened here. It pits one family against their own homeowners association in a dispute that got so serious it went all the way to a formal administrative hearing. And that's the opening shot, right from the homeowner's attorney, Craig Klein. He's not pulling any punches here. He's framing this not as some simple mistake, but as a 4-year-long battle that, in his words, was started intentionally by the HOA board. So what's at the heart of all this? Well, the HOA slapped the family with an official violation notice, and it was a big one. They claimed the family's developed land, what they call the building envelope, was 16,000 square feet over the legal limit of 22,000. That's a massive overage, and it's the accusation that kicked this whole formal hearing into gear. So you've got to be asking yourself, how did these two sides come up with such wildly different numbers? I mean, we're not talking about a small disagreement here. Their conclusions were literally worlds apart. And the answer? Well, it's not just about who they hired, but how those experts did their jobs. All right, so let's meet the players. On one side, you have the homeowners guy, Stephen McClam. On the other, the HOA's expert, a Mr. Teague. Now, it's really important to know, both of these guys are licensed, registered professionals in Arizona. So we're not talking about some amateur hour here. These are two qualified experts looking at the exact same piece of property. Let's start with the homeowner's number. Their surveyor, McClam, he did what he called a boots-on-the-ground survey. That means he actually walked the property line and used custom aerial images. His final number? 17,451 square feet. That is well inside the legal limit. No problem here. But then you look at the HOA's claim. They're saying the total area is almost 38,000 square feet. According to them, this is a gigantic violation, 16,000 square feet over the line. So, just to be clear, one expert says they're perfectly fine, and the other leads the HOA to believe they're in major violation. So how in the world is a 20,000 square foot difference even possible, right? That's the huge question at the center of this hearing. Are they measuring completely different things? Did someone just mess up badly? Well, the answer, it turns out, is all in the methods. And this slide right here tells you everything you need to know. McClam, the homeowners guy, did a physical survey. He literally walked the land. Teague, on the other hand, working for the HOA, did his analysis from an office using publicly available online mapping tools. A huge difference in approach. Now, as if this whole property line thing wasn't enough, there was another incident that the homeowners brought up. They believe it shows a pattern of them being unfairly targeted. And it might sound kind of trivial, but it adds this whole other layer to their claim of harassment. And it all started with a simple flagpole. So the HOA approved their request for a small 6-foot flagpole, but the approval came with these really weird strings attached. They said it had to be on the side of the house and that this portable pole could not be moved. But here's the kicker. The HOA president later got up and admitted under oath that the board doesn't even have the right to regulate mobile flagpoles in the first place. And you see, for the homeowners and their lawyer, this wasn't just some silly argument over a flagpole. No way. To them, it was just another example of what they called a campaign of heavy-handedness and selective enforcement. They felt the HOA was going out of its way to make up difficult, nonsensical rules that applied only to them. Okay, now, this is where the story takes a really dramatic turn. To prove their case, the HOA calls their own expert surveyor, Mr. Teague, to testify under oath. And obviously the expectation is that he's going to get up there, stand by his report, and confirm this massive 16,000 square foot violation. So the homeowner's lawyer gets his chance to ask questions, and he cuts right to the chase. He asks Mr. Teague a very direct question. Did your report, the very one this whole violation is based on, did it actually prove my clients exceeded the building envelope? And his answer, wow, it was an absolute bombshell. Under oath, the HOA's own expert says his report never concluded the homeowners were in violation. He said it flat out. I did not say that the envelope had been exceeded. And then he added that making that kind of judgment call, well, it is not my task. He then explained what he was actually asked to do. His job was simple, just measure 2 separate areas using the online tool. One was the house area, which came out to about 16,300 square feet. The other was a separate yard to the east. He testified that nobody ever asked him to decide if that yard was actually part of the official building envelope. He just provided the numbers, that's it. So let that sink in for a second. The entire reason for this violation notice, the very document that dragged everyone into this formal hearing, was based on a surveyor's report. And the guy who wrote the report says under oath that it doesn't prove what the HOA claims it proves. Just incredible.
So after that bombshell testimony, the hearing moves on to closing arguments. And this is where you really see two completely different realities being presented to the judge. Was this a targeted campaign of harassment? Or was this just a volunteer board trying to do the right thing?
On one hand, you have the homeowner's position, which is pretty clear. This was a biased attack. They argue the board twisted a surveyor's report just to go after them, all while ignoring other potential problems in the neighborhood. But the HOA, they paint a totally different picture. They say, hey, we're just volunteers doing our best with no malice based on a report we paid good money for. But maybe the most telling piece of evidence came from the HOA president herself. Get this. She testified that she thinks maybe 46 properties in the community could be in violation. 46! Yet she admitted they'd only sent out 2 formal enforcement letters. And this is the big one, these homeowners were the only residents the HOA had ever hired a surveyor to investigate. The only one. And that's really what this all boils down to, isn't it? It leaves us with this huge, provocative question that this entire case hangs on. It's something communities everywhere struggle with. At what point does a board, just trying to enforce the rules, cross a line? When does it stop being about keeping things fair for everyone and start becoming selective enforcement or maybe even harassment?